Good morning, good morning, good morning again, folks. Merry stupid o'clock. Now, why am I wearing the same clothes as yesterday? I'll tell you. It's not yesterday yet, folks. I am doing this video in advance to put out tomorrow because getting sleep was nice today. I would like to get some more tomorrow. We're going back to that horrible world known as the JRC, and we're getting a little bit further on in time. This is the time period of 1982. If you've read the Wikipedia page on the JRC slash back then the BRI, this right here from the state of California is rather pertinent to their history. This is for one of their facilities they had out in California. And this was when the JRC slash BRI became more widely known for their cruelty. This is coming from the Office of the Attorney General of the State of California. All right. Before the Department of Social Services, State of California, in the matter of the accusation against the Behavioral Research Institute of California. First amended accusation statement of issues. All right. Before we get into it, a few of the usual disclaimers. I kind of got ahead of myself there. All right, first, folks. You are going to see the link to the report we're getting ready to go over right there in the description box, alongside the other pertinent links to the Stop the Shocks campaign, including Autistic Hoya's massive archive, the templates, sign your name, click on your senator, and the ever-present change.org Shut the Judge Rotenberg Center Down petition. Now, this report may not come from 1979, but it does come from 1982. So if there's any ableist language in there, just know I am taking it from the report. It is not my general way of speaking about my peers. Now, when we talk about the JRC, you're going to hear vivid descriptions of and catch clips of surveillance footage of people with disabilities being tortured and abused. If you have young children present, please use your headphones, all right? All right, now, it is 8:46 a.m. in the morning, even though I'll probably be putting this out about around 3 a.m. as per usual. So, folks, I'm still stressed to the gills. God, it's like my default setting. I need a vacation that lasts a decade. If the powers that be are taking any requests. So if I stumble over any of my words this morning, my apologies in advance, all right? Okay. Let's get started. Comes now Ann Bersinger, complainant herein, and amends the accusation. And this matter signed on October the 20th, 1981, and previously served on respondent. This amended accusation supersedes the original accusation in its entirety, either restating or amending all parts thereof, so that the parties may conveniently refer to a single document. This amendment has become necessary for three reasons. First, respondent's license renewal application has been denied, and respondent has appealed therefrom and requested a hearing thereon. Second, a number of allegations made in the original accusation needed to be clarified, expanded upon, or made more specific for the benefit of the respondent. Third, a very limited number of allegations based on facts which have recently come to the complainant's attention has been added. Go California. Complainant now alleges the following as cause for the revocation of respondent's license and special permit to operate and maintain a community care facility, and as cause for denial of respondent's application to renew its license and special permit. Go California. Massachusetts. They revoked it in 1982 before they started electrocuting people. Just saying. Just saying is all. Okay. Complaint now alleges the following as cause for revocation of the respondent's license and special permit to operate and maintain a community care facility, as cause for denial of respondent's application to renew its license and special permit. Yes, I'm rereading. Complainant is the duly appointed Deputy Director, Community Care Licensing Division, Department of Social Services, State of California, and makes and files this accusation in such official capacity and not otherwise. Second, pursuant to the Health and Safety Code Section 1525, the Department of Social Services, hereinafter Social Services or Department, is the agency of the State of California responsible for the issuance or denial of a license to operate a community care facility or of a special permit, and for the issuance or denial of a renewal of a license or a special permit pursuant to Health and Safety Code Section 1550. Social Services is authorized to suspend or revoke any license or special permit for violation of statutes or of rules and regulations promulgated pursuant to the Community Care Facilities Act, Health and Safety Code Section 1500 et sec, whatever. 3. Excuse me. Prior to the July 1st, 1978, all functions of social services relevant to this accusation were performed. I'm sorry, it blanks it out, guys. Predecessor in interest, the State Department of Health. Insofar as they are relevant to this accusation, all actions taken by Health prior to July 1st, 1978 are to be given the same force and effect as though they had been taken by Social Services. Number 4. Respondent was licensed on October 25, 1977 to operate a group home for 6 children called the Behavioral Research Institute, thereinafter BRI, at Blank Northbridge, California facility. On October the 25th, 1977, BRI was authorized to conduct behavior modification and to utilize negative reinforcers in the treatment of autistic children and adults in accordance with the BRI's then existing program. Yeah, you all fucking sick. Yeah, we're gonna beat the behavior out of him. We're gonna beat that autism out of that kid. Sorry, that's not how it works. A true and correct copy of BRI's then existing program of negative reinforcers or aversives is attached hereto as Exhibit A. A true and correct copy of authorization letter is attached hereto as Exhibit B. On March 30th, 1979, the facility was issued a special permit to provide aversive behavior interventions, hereinafter special permit. A true and correct copy of the special permit is attaching hereto Exhibit C. Said permit, which superseded all previous authorizations, was conditioned on the compliance with the general requirements contained therein, with the special licensing requirements contained therein, hereinafter the A standards, and with the special permit program requirements contained in the February 18, 1979 draft of the California Guidelines for the Use of Behavior Interventions to Restore Personal Autonomy. Can somebody explain to me how the fuck being punished for being disabled restores one's autonomy? Make it make sense, people. Punishment does not give one autonomy, it takes it away. God, it's like I'm talking to kindergartners. Adversive behavior interventions as a specific case herein after the B standards of the draft guidelines. A true and correct copy of the draft guidelines is attached hereto as Exhibit D. Respondent is currently licensed under license number blah 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 to care for 6 children or adults. As used herein, the term respondent refers to the license, and to its agents, consultants, and employees. Complainant seeks revocation of respondent's license on the ground that respondent has violated or permitted the violation of applicable statutes and regulations in the manner set forth below. All right, now we're getting to the body of it here. Oh boy. Complainant seeks revocation of respondent's special permit on the grounds that the respondent has violated or permitted the violation of licensing statutes and regulations, of general requirements set forth in the special permit, of A standards and of the B standards or draft guidelines in the manner set forth below. Assuming arguendo that the letter of October the 25th, 1977, authorizing BRI to conduct behavior modification, was not superseded by the special permit, complainant seeks revocation of that authorization on the grounds that the respondent has violated or permitted the violation of the licensing statutes and regulations and of conditions set forth in the authorization letter. During the pendency of this processing, respondent's license and special permit expired October the 24th, 1981. On or about June 18th, 1981, respondent filed an application for renewal of that license. Section 1525 of the Health and Safety Code provides in relevant part that if the director of the Department of Social Services finds that the applicant is not in compliance with the laws or regulations of Division 2 of the Health and Safety Code, Sections 1500 through 1565, he shall deny the applicant a license renewal, special permit, or permit renewal. So if he finds that what is going on at a particular care facility, which is also the case out here in Missouri, by the way, and it is complete operating that is against the violations of our health and safety laws and in direct violation with ADA laws and the Disability Bill of Rights laws we have out here, then our folks here, and we call it DMH out here, DMH then has the right to yank its license. Just saying. So, looks like California operates the same way. If only Massachusetts could untie their DDS's hands and let them do their jobs, right? Okay, moving on. Sorry. Section 80132 of Title 22 of California Administrative Code provides in relevant part as follows. Denial of a renewal of license or special permit. For the purposes of 5132, the term license shall also mean and include social permit, and the term license shall also mean and include the holder of a special permit. The licensing agency shall deny an applicant for a renewal of license when the license is not substantial compliance with the applicable law or regulations as defined by Section 80133 at the time of the renewal visit. Remember, this is when adverses were considered the freaking gold standard of medical care when it came to autistics, folks. So if that is the gold standard of the time, if they found the BRI going even further than that, says a lot, doesn't it? The licensing agency shall deny the renewal of application when lack of substantial compliance has resulted in the department's action to suspend or revoke the license to seek other remedies as provided by law. When a renewal application is denied in accordance with this sanction, and the license appeals the denial, the licensing agency shall, upon written request from the license within the 15-day period, issue a license pending adoption by the department of a decision on the administrative action. Social Services denied respondent application for renewal of its license and special permit, finding that the respondent was not in substantial compliance with applicable law and regulations at the time the renewal application was submitted. The basis for this finding are acts and conditions described in this accusation as ongoing, and the acts and conditions noted during June 5, 1981, and the subsequent licensing evaluations. On or about October the 28th, 1981, respondent appealed the denial of the license and special permit. Pursuant to Section 80132, Social Services has issued a respondent a license and special permit which permits it to operate pending adoption by Social Services of a decision in this action. Social Services has duly adopted regulations which are applicable regulations within the meaning of Section 1550 of the Health and Safety Code. Said regulations are found in the Division 6, Title 22 of the California Administrative Code, beginning with Section 80001. Respondent is subject to the provisions of these regulations. Except as otherwise noted, all sections hereinafter referred to will be from Title 22, California Administrative Code. Section 80403 provides as follows. Unless improved by the Department Licensing Agency, no form of behavioral restraint shall be used in caring for any person served. Such restraint includes the use of any appliance or device to confine a person to a bed, chair, or any other object, or deprive him of the use of his arms, hands, or feet as a means of controlling his behavior. Ooh. BRI is not approved to use those methods, now known as the JRC, then yeah, go California. Respondent has violated Section 80403 on a continual basis as follows: by using restraints as a means of controlling the resident's behavior. Respondent kept resident restrained by the use of appliance or devices on the following occasions and on other unknown occasions prior to July 17, 1981. On the morning of July 17, 1981, Blank was restrained in bed by an arrangement which kept him flat on his stomach in bed. Blank died between 9 to 10 a.m. on this date while being so restrained. On June 5, 1981, Blank was restrained in bed before getting up at 8:10 a.m. He was restrained on his stomach with a plastic cuff on each leg and on his left hand. The restraints were tied to the bed frame. His right hand was covered by a sock, which was tied at the wrist by a small thin belt. Respondent is informed and believes and therefore alleges that Blank was regularly restrained in this or a similar fashion while he was in bed. On June 5, 1981, Blank was restrained by the use of foot and handcuffs. There was an excitation of the right ankle immediately below the foot cuff. Both hands were swollen. The left hand was bluish in color. There were marks from the cuffs at the levels of the wrists. His fingers were swollen and his wrist formed in shape. Because Blank suffered from circulatory disorder, the type of restraint to which he was subjected to was contraindicated. On or about March 10, 1981, respondent caused restraints to be used on Blank. On or about February 5, 1981, Blank was subjected to restraints by respondent. Blank was restrained by both wrists to a chair with a restraint around his chest. F. In or about December 1980 and for an unknown period of time after that month, Blank frequently was kept in restraints. Respondent staff used mechanical restraints in lieu of acceptable procedures to prevent Blank from grabbing people, throwing things, or attempting to gouge out his eyes. Gotta victim blame. In or about December 1980, for an unknown period of time after that month, Blank was restrained to a chair by a vest device to prevent him from running around. During his period of residence, Blank was frequently in restraints, at other times not specifically known to compliant. Respondent kept resident Blank restrained by the use of appliances or devices on the following occasions, and on other occasions not specifically known to complainant before and after those dates. On or about the night of June the 4th through 5th, 1981, Blank was made to sleep with handcuffs, which restrained his hand and arm movement. The handcuffs were attached to a hard, resistant cloth belt with a metal buckle on the back. After arising about June 5th, 1981, Blank was made to wear plastic handcuffs, were attached to a hard, resistant cloth belt with a metal buckle on the back. There was a 2 centimeter by 2 centimeter red sore on his back at the level of the metal buckle. There was a red area of 4 centimeters by 4 centimeters, clearly delineated on the left wrist that was visible as an employee checked the cuffs. On or about April the 13th, 1981, Blank was made to lie face down with his hands restrained by a green plastic cuff behind his back. On April 13th, 1981, Blank had a reddened area the size of a $50 on his left ankle, in the area where the leg restraints would lie. Complaint is informed and believes and therein alleges that this reddened area was a result of the use of the leg restraints on Blank. On or about March 10th, 1981, Blank was in restraints. On or about March 1st, 1981, Blank was restrained in a large black chair by himself in the kitchen. Hands were tied to the chair, his feet were tied to the bottom of the chair, and a huge box covered his hand and torso. He kept in this position for at least 1 hour. On the occasion of October 1980, Blank was restrained to a chair with a string around his torso and the back of the chair. On or about November the 4th, 1980, Blank was in restraints with both hands restrained behind his back and both feet bound together. During his period of residence at BRI, Blank was frequently in restraints. On numerous occasions, his wrists and hands would be bruised and or blue. Respondents kept resident Blank restrained by the use of appliances or devices on the following occasions, and on other occasions not specifically known to the complainant before and after these dates. On June the 5th, 1981, Blank was restrained with the plastic handcuffs that were attached to a hard and resistant cloth belt at his waist with a metal buckle on the back. On or about April 13th, 1981, was restrained by a table by both wrists and the right ankle. A representative of the respondent told a department evaluator that Blank was restrained in this fashion because he was a hitter and a fire setter. Yes, because, they're going to continue to blame the victims. Why is he a fire setter? I would set fire to your fucking facility. Just saying. On or about March 10th, 1981, respondent was using restraints on Blank. On occasion during the period from September 3rd, 1980 to March 1981, and in known occasions before and after this period, Blank was placed in distraction elimination, or isolation deprivation, or time out, therein referred to as isolation, for periods lasting up to 24 hours. This procedure was used by respondent as an aversive consequence for Blank hitting. In isolation, Blank was seated in a chair at a table and restrained to the table by his wrists and ankles. Boxes would then be stacked around him to prevent him from seeing anyone or anything in the room. During that period, he either received no meals or was fed lettuce with mayonnaise 3 times daily and a protein drink once a day as his only food. The bottom of his foot would be pinched every hour. The pinches were severe enough that Blank to scream. No one was allowed to talk to Blank or to look him in the eye while he was in isolation. On occasion, he would not be allowed to go to the bathroom and would urinate in his pants. His restraints would not be loosened whether or not he complied. Employees were instructed not to respond to him during such periods of isolation. Employees were instructed to give Blank a water squirt from over the boxes as they passed by. If Blank talked to an employee, the employee was instructed to administer a water squirt to Blank. On numerous occasions during 1980 and 1981, Blank was restrained in a special chair that restrained his arms and legs to the chair and restrained him around the chest. Blank would be made to wear a helmet. The restraints on the chair were designed that Blank had to limited hand movement. On or about February the 5th, 1981, Blank was in restraints. Blank was restricted to a chair in a kitchen treatment area by both ankles and both wrists. During his period of residence at BRI, Blank was frequently in restraints. His hands and wrists would frequently be bruised and or blue because of restraints. On or about June 5th, 1981, respondents recorded a restraint check when restraints had not in fact been checked. Section 8083 provides as follows. So, we'll get into more of this later, but this is very telling, isn't it? It's all stuff we've heard before. It's all stuff that's still going on. Plus, you have the shocking on top of it. Now, California in 1982, after being shown all this evidence, did not tie their Department of Mental Health, the Department of Social Service, they did not tie their hands behind their back. They did not allow the BRI to be protected by the courts. They yanked their license. But what I find interesting about California is that in spite of the fact that they do not allow them to operate in the states, it is known that they send students to the East Coast facility in Canton, Massachusetts. It's like all of a sudden the state has collective amnesia and they no longer remember why they shut down the facility in California in the first place. Yeah. Just putting it out there. Well, we'll definitely go ahead and get back to this tomorrow, but for this morning, I'm going to go ahead and close out. We don't get very many views on this channel, especially on this subject. The few that we do get do tend to get removed from time to time. So, folks, please don't forget to hit that like button, hit subscribe, and don't forget to hit the comments. Do appreciate your time this morning, and as always, be here at Spilling Tea. Hope you have a good one. Bye-bye.